Yes, that's a good one.
Well, Lord, before lunch we were looking at the various collections of cases relied on by the respondent in support of the supposed broader fraud dues. The next collection is identified at paragraph 63 of their written case, at page 128, where we see the heading Fraud on Personal Customer, Virgie, and Fraud on Sole Signatory, Weir. Now, Virgie is at tab 20, page 2767. And it was a very short extempore judgment of Mr. Justice Hart on an application to set aside a statutory demand. So I would respectfully suggest there are limits as to what can be read into it. The decision concerned an application by Mr. Virgie to set aside a statutory demand served on him by the defendant bank. And the statutory demand was for £21,000 odd, and in the main related to a cheque which had been presented to and indeed honoured by the bank from Mr. Virgie's personal account. The basis of the application is explained at page 2768. In the right-hand column, second full paragraph down, in essence, Mr. Virgie's application is based on the proposition that the bank was in breach of duty of care which it owed him when it honoured the cheque, it being Mr. Virgie's case that the cheque was presented dishonestly in circumstances in which the bank should not have paid out in respect of it without making inquiry directly of Mr. Virgie. The circumstances in which the cheque is said to have been presented dishonestly are, according to Mr. Virgie, these. He says that some date, he is not specific as to the time, he gave to Mr. Sonji, who appears to have been a business acquaintance or partner of Mr. Virgie, 2 blank cheques drawn on the bank and signed by Mr. Virgie. Mr. Virgie says that the understanding between him and Mr. Sonji was that Mr. Sonji would not have presented the cheque for payment except for the purpose of withdrawing commissions owing from their joint commercial enterprises. Mr. Virgie says that it was in breach of that understanding that Mr. Sonji filled in both dates and payees on both the cheques in late 1999 and thereby caused them to be presented for payment. And then over the page at 2769, the second full paragraph down on the left-hand side, however that may be, the essential ground upon which it is suggested that the bank was in breach of a duty of care owed to Mr. Virgie is that the bank ought to have realised that there was something wrong with the situation when the cheque was presented it for payment and should then have made inquiry, and on the making of the inquiry it would have become clear that Mr. Virgie was not authorising the payment. So just pausing there, this is a case where there was an issue as to whether or not Mr. Virgie had in fact authorised the transaction. So it's not a case akin to the respondents. But before we turn to look at what was decided by Mr. Justice Hart, it's worth noting that based on the facts as alleged by Mr. Virgie, it seems there was an argument open to him that the cheque was not enforceable against him by the bank under Section 20 of the Bills of Exchange Act, because having signed the cheque in blank and delivered it to Mr. Sonji with authority to fill it up, the cheque was not filled up by Mr. Sonji strictly in accordance with the authority given him. That argument, though, doesn't appear to have been put before the court, but nonetheless it would, we respectfully suggest, provide the answer to this case. So then, returning to what was decided, page 2770, top left-hand side, as Miss Fraser, she was for Mr. Virgie, submitted, and I'm content to accept, the duty of care owed by a bank to his customer for this purpose can be taken from the judgment of Mr. Stain, as he then was in Quince Care. And he then sets out various passages from Quince Care. And he then says underneath that quote, I think emphasise that that passage is of course dealing with the standard of care required by a banker when dealing with the account of a company. In other words, a situation where the signatory of the cheque is necessarily not himself the account holder. Similarly, in Nipkin Gorman, where the question had to be considered both at first instance and in the Court of Appeal, the court had to deal with a case where the signatory of the cheque was not the only person who was liable on it. It seems to me necessarily the case that the possibility of fraud is always more likely to be present in a case where those circumstances obtain. In the present case, we are dealing with a situation where the apparent signatory of the cheque is himself the account holder. In those circumstances, if the bank has no reason not to believe the signature to be genuine, no question on the face of it can arise of some fraud being committed on the signatory. He is on the face of it requesting the bank to make payment at his own expense. Reference is then made to the Barclays Bank and Sims case, and then the judge says that he considers that to be conclusive of the case, unless it can be said that there is something in the circumstances which were or should have been present to the bank's mind when the cheque was presented, which should have given it pause for thought. On the face of it, there was, by virtue of the presentation of the cheque, a request for an overdraft in that amount, which the bank could choose whether or not to accede to. On analysis, it seems to me the only circumstances that Mr. Vergy really relies upon is showing that the bank was somehow in breach of its duty of care to him in deciding to accede to that request, is the fact that he had not previously, in respect of this account, made such a request. But that, it seems to me, is quite insufficient to put the bank on notice that there was something sufficiently odd about the request to suggest the possibility that some fraud was being committed in connection with the cheque. And then over the page 2771, having referred to the evidence relating to Mr. Betts from the bank, he then says, for the reasons I've indicated, I do not think they were under any such duty. Now, we respectfully say, far from supporting the respondent's case, I would suggest that this decision involved a conventional application of the quince care duty. Mr. Vergy, the customer, had signed blank cheques and given authority to his business partner, Mr. Sonji, to complete the cheques on certain terms as his agent. The agent breached the terms of that authority by completing and presenting the cheques in fraud of the customer. And as a result, properly viewed, this is also an agency case involving a payment said to be unauthorised. Now, Lord Justice Burr said at paragraph 42 that Mr. Justice Hart's judgment explicitly contemplates that the banker's duty when presented with an instrument to pay made by an individual customer is not unqualified. But that, with respect, pays insufficient regard to the facts of the case, and that the focus remained on whether the bank had some reason to think that the instructions by way of the cheques were not valid. So that's Vergy. The decision in the Weir case also does not assist the respondent. We don't need to turn it up, but for your Lordship's note, a copy of the judgment of the Scottish Court of Session in the House is at page 2772. And in short, that case can't assist the respondent as it concerned an entirely different issue. It was not a quince care case. It instead concerned the issue as to whether an accepted duty owed by the bank to advise its customer if it became aware of cheques being drawn on the account with forged signatures could be owed not just to the customer but also to the sole signatory on the account who operated the account under a power of attorney. And unsurprisingly, it was held that arguably it could, on the basis that as the account was operated by the agent as the sole signatory, there was sufficient proximity for the accepted duty to be owed to the agent. So the decision does not concern or support some wider duty of inquiry of the sort contended for by the respondent. So the bank submits that the respondent's proposition of law is not established by the cases that are relied on in support of it. I would add that the respondent's argument also ignores the many passages in the authorities that refer to the quince care duty being narrow, exceptional, and arising in very limited circumstances. Because if my learned friend is right that the quince care duty is just one aspect of a broader duty of inquiry on the part of the bank, that those passages make little or no sense. At paragraph 73 of the Respondent's written case, at page 132, there is a section headed Fraud Genus, Fraud as a Special Category. We see that just above paragraph 73. And my learned friend starts this part of his argument by relying on the maxim that fraud unravels all. But with respect to him, his analysis is too simplistic because it fails to differentiate between two separate things. First, the instructions received by the bank pursuant to the mandate, and second, the transactions between Mrs. Philipp and the fraudster. And as I said this morning, that the payment instructions were not vitiated, to use Lord Justice Burse's word, by the fraud perpetrated on Mrs. Philipp by the fraudster. So fraud does not unravel the payment instructions. It's also instructive to note in passing what my learned friend says in both paragraphs 74 and 75 about the factors vitiating an instruction not being limited to fraud. We see in 74 the words in brackets in the second line, and may properly include other vitiating factors such as mistake. And then in the second line of paragraph 75, a wider genus than fraud, including mistake. So he says that Lord Justice Burse's analysis would apply to an instruction vitiated, to use his word, by mistake too. Now that serves to demonstrate the incredible breadth of the Court of Appeal's argument, the Court of Appeal's judgment, or at least how enthusiastic litigators, of which I'm sure there will be many, will likely contend that it should be interpreted. The implications of this are considerable if the quince care duty extends to cover any sort of defect in the customer's decision-making process. And on any view, that would represent a massive development in the law with radical consequences. My learned friend goes on in paragraph 75 to rely on the wording we saw this morning used in some of the cases along the lines that banks shouldn't facilitate fraud. But those words with respect cannot be elevated to the status that the respondent wishes to place on them. They need to be read in the context in which they were used. And they cannot provide a foothold to suggest that the case law can be read in a way that is not consistent with its central reasoning. It's also important to view this aspect of the respondent's argument within the broader confines of the obligations on a bank in relation to financial crime and money laundering. These have been addressed in our and UK Finance's written case, but I'd highlight 4 points at this stage. First, banks are under a number of legislative and regulatory obligations in relation to financial crime and money laundering. However, none of those are actionable by customers. Second, the money laundering regime, factoring in the various considerations and balances to which it gave rise, was introduced by way of detailed provisions of legislation and regulation. The courts have rightly recognised that Parliament has struck a precise and workable balance of conflicting interests in the Proceeds of Crime Act 2002, and that the Act reflects a clear policy decision by Parliament that the fight against money laundering should take priority over the performance of the mandate in the limited circumstances prescribed by the Act. Third, as I mentioned this morning, the money laundering obligations are not engaged in an APP fraud context because the innocent party, the payer, is not instructing the bank to deal with criminal property. The monies only become criminal after they are received by the fraudster. And fourth, even where the provisions of the 2002 Act are engaged, the obligations placed on a bank are clear and specific, and indeed no obligation of investigation is imposed on a bank, which instead is handed over to the National Crime Agency. So Parliament has struck a careful balance in deciding in what circumstances the performance of the banker-customer relationship should be impacted. Those circumstances do not arise on the facts of the respondent, yet she contends for a duty which is more onerous and open-ended than that even imposed by the 2002 Act. If we turn to paragraph 35, subparagraph 4 of the respondent's written case, at page 119, we see a suggestion that there is case law outside the immediate banking sector showing why the court may step in to set a requirement to refrain from action, negative duty, and some investigation, positive duty, in cases where an agent is providing a service to their principal, and not simply leave it to ordinary industry practice. Now that is then elaborated on in paragraph 79 at page 134. And the two cases cited in support of this supposed proposition are in paragraph 80 and paragraph 81, the Sidaway case and Edward Wong. I can deal with this very briefly. Neither Sidaway nor Edward Wong can be of any assistance to the respondent because the duty on the bank to exercise skill and care in and about executing the instruction is very different in scope and nature to the duty on a doctor or a solicitor, and the duty on the bank is not advisory in nature.
At the moment, I'm inclined to think that a negligence analysis can't add anything.
No.
Because it has to rest on an assumption of responsibility.
Yes.
And that just takes you back to the contract.
Yes, I agree. And that's the point we tried to convey in our note of yesterday evening. That if you're, and indeed that's consistent with the Lord Scarman approach in the Tai-Hing Cotton Mill case, that if you can't get yourself within the four corners of the contract, whether express terms or implied terms, the law of tort is not going to provide something that goes beyond that. So I want to say something briefly now regarding the cases from the other jurisdictions. There are, it's fair to say, a significant number of cases that have been referred to in the respondent's written case, but it's respectfully suggested that the court is unlikely to be assisted by them. The vast bulk of the cases fall into two categories. Either conventional applications of the quince care duty, properly so called, or cases where there was an issue as to whether the instruction was authorised or not. There is not a single case referred to which supports the extension of the quince care duty into an APP fraud context. There is only one case of the many that have been cited that concerned an APP fraud, and that is the British Columbian case of Zeng and Bank of China, which is at page 2981. Now, my learned friend in his written case at paragraph 148 refers to this case as being a decision of the Canadian Appellate Court, but that description may slightly mislead, as it's a decision of a single judge on appeal from the master. The master had struck out the claim as having no reasonable prospect of success, and the issue is whether or not the claim raised issues that were properly arguable. Ms. Zeng was deceived by a fraudster into making a transfer from her Canadian bank account to an account in Hong Kong. And the judge concluded that it was not plain and obvious that the claim was bound to fail. We can see that at paragraph 34 on page 2992. However, the decision can provide no assistance to the respondent because it was common ground that the bank owed Ms. Zeng a duty to make inquiries of her in the face of signs of potential fraud. And we can see that in paragraphs 16 and 17 on page 2987. Where it said that on appeal, Ms. Zeng argues the master erred by approaching the claim as one based on a fiduciary duty. She argues the bank has an implied contractual obligation, independent of any fiduciary obligation, to discharge its obligations to its customers with reasonable care and skill, and this includes a duty to make inquiries of her in the face of signs of potential fraud. She argues the signs of fraud in this case were white hot. And then 17, the bank acknowledged the implied contractual obligation, but argues the notice of civil claim discloses no facts that put a reasonable banker on notice of potential fraud, and thus a duty to inquiry never arose. So there was no argument about the existence of the duty. The question instead was whether or not the facts triggered the duty. So there was no submission, it would seem, by the bank that there was a legal distinction between an internal fraud and an external fraud. And the judge did not refer to any possible distinction between the two situations. At paragraph 33 on page 2992, the judge simply remarked in passing that this was not a case where the fraudster was making the transaction in question. If you look at paragraph 33, he says, unlike most of the cases cited by the parties, this is not a case where the fraudster was making the transaction in question. Rather, the allegation is the fraudster was operating behind the scenes, using a form of duress to compel Ms. Zeng to transfer the money. The only cases like this cited by counsel have evidently not yet gone to trial. The judge, having made that observation, there doesn't appear to be any suggestion that that might have made a difference to the applicable legal principles. And certainly no reference was made to any authority on the point, such indeed as His Honour Judge Russell's judgment in this case, or the judgment in Seekers, or the judgment from Look Wing Yang. So that's the high point, as it were, of the foreign cases. I want to deal, if I've got time, with 3 or 4 others that have been put into the primary authorities bundle by the respondents. One assumes that they're the ones that my own friend thinks are the most important. The second case is the New Zealand case of Tandem Group and ASB Bank. And that's at page 2962. Now, this was not an APP fraud case, but it involved an authorised cheque. And the facts were that the customer's accountant deceived them into giving him a signed cheque for $200,000, which intended to be deposited into a tax-efficient account. But subsequently, the accountant dishonestly completed the cheque by naming himself as the payee. Now, no point, much like Virgin, no point seems to have been taken that the cheque was unenforceable under the New Zealand equivalent of Section 20 of the Bills of Exchange Act. Because on the face of it, that would have been a compelling argument, a compelling claim against the bank. Instead, the argument was that the bank acted in breach of duty by paying out the proceeds of the cheque to the fraudster. We can see that at paragraph 28 on page 2969. The judge cited Quince-Care and some of the other familiar authorities in paragraph 31. And then in paragraph 34, refer to Tyree banking law on New Zealand, which summarised the New Zealand legal position as follows. There is an implied duty to make inquiry before paying an apparently authorised cheque. The reasonable and honest banker who knew the relevant facts would have considered that there was a serious or real possibility that his customer might be being defrauded, and then held that that duty was arguable in paragraph 34. However, neither the judge nor the parties adverted to the fact that all of the previous authorities concerned instructions issued by fraudulent agents, whereas this case arguably did not. And so there was no discussion, it would seem, as to whether the Quince-Care duty could or should extend to cases of external fraud. In any event, it's possible to view the case as being one of a dishonest agent, given that the blank cheque was given to the accountant as the agent so that he could complete and submit it to the tax authorities on their behalf. The next case relied on by the respondent is Sansom and Westpac Banking Corp, a decision of the New South Wales Court of Appeal. That's at page 5844. Now, this was a case where a husband and wife had a joint account, and the wife ran up a large overdraft without the husband's knowledge. And the husband and wife were both held liable to repay the overdraft. The husband appealed and ran various arguments, one of which was that the bank had acted in breach of duty of care to him in failing to inquire whether he approved of the wife's transactions. One can see that at 5849 at the top of the page. However, the court dismissed the appeal, holding that the bank was not under any duty to make inquiry of the husband concerning the wife's use of the joint account. It's also to be noted that this case did not concern an account in credit. It concerned an account in debit, where the bank was having to decide whether to honour the cheques. One can see that at 5856 and 5861. And the argument was that the bank should have been on inquiry in authorising the account to go overdrawn. In that situation, the bank is not, of course, obliged to honour a cheque in the same way as it would if the account were in credit, and the bank is the customer's debtor. So the argument about the duty of inquiry was tied to what the bank was doing when it was deciding whether or not to grant the overdraft, which obviously is quite different to the scenario with which the respondent is faced. The next case relied on is a case called Su and Mei and Overseas Chinese Banking Corps, a decision of the Singaporean Court of Appeal. That's at page 2831. And this case cannot assist the respondent either. This case involved a claim by the customer against the bank for failing to comply with a payment instruction, not a claim that the bank had paid out on a fraudulent instruction. But moreover, the case concerned the issue as to whether the bank had received a valid instruction from the customer. The customer was an elderly lady. She held substantial deposits with the bank of over 8 million Singaporean dollars, and she attended at the bank with her adopted daughter Amy, who had instructed the bank to open a joint account in their names and to transfer all of the deposits into that account. The bank was concerned that the customer appeared dazed and didn't know what she was doing. Therefore, they were concerned that they did not have a valid instruction from the customer and accordingly refused to act on it. The customer subsequently sued the bank for having failed to act on her instruction. And the court held that the bank had acted reasonably in not complying with the instruction because it had concerns that the instruction was not valid. And we can see that at paragraph 31 on page 2839. Therefore, the case is of no assistance to the respondent, as it concerns a very different issue, namely whether the bank had received a valid instruction.
Is there any gap, so to speak, between a situation in which the bank has a duty to execute the instruction and a situation in which it has a duty not to, because it's on inquiry as to grounds for believing that it's not authorised?
I'm not quite sure what Lord means by any gap.
Well, I mean any room for discretion on the part of the bank, or is it either under a duty to pay or under a duty not to pay?
Yes, I think that's right. In that sense, there is no gap. So it's a binary question.
Yeah.
Finally, we have the case of Aegis Resources versus United Bank of India. That's at page 2801. Now, this case concerned a credit facility provided by the bank to the customer, and drawdown occurred under the facility by way of the customer submitting to the bank, usually by way of email and or fax, a payment instruction using a template provided by the bank. The bank processed two instructions, which it subsequently transpired had been submitted fraudulently by a fraudster who had hacked into the customer's email account. The customer then sued the bank, putting its claim on two bases. First, that the payments were made in breach of mandate, as the instructions had not been issued by the customer at all. And second, that the bank had breached the duty to exercise reasonable skill and care in executing the instructions. And we can see that at paragraph 50 on page 2809. The so-called mandate basis and the duty of care basis. Now, the judge held that the bank had acted in breach of mandate on the basis that the bank had not acted on instructions from the customer, but the fraudster. And in doing so, he held that the bank's contractual terms did not entitle the bank to debit the account on the basis of a forged instrument or forged instruction if the bank had acted negligently. So the customer won on the principal basis, i.e. the payment was outside mandate. However, the judge then went on to consider the customer's alternative claim in negligence. We can see that at paragraph 107 on page 2816. And we see in paragraph 107 that he said he was doing so on the basis that the conclusion he had reached on the breach of mandate case was wrong. Now, it's difficult with respect to see how, on that hypothesis, there was any room for the Quint's Care claim. The judge had already found that the bank had acted negligently in ruling against it on the breach of mandate. It was the negligence that prevented the bank relying on its terms and conditions. Therefore, if he was wrong in that conclusion, it follows there could be no Quint's Care claim because ex hypothesi, the bank would not have been negligent. There also could have been no Quint's Care claim if the judge's conclusion on breach of mandate was correct, as in that scenario, the bank was not entitled to debit the account at all, and it was strictly liable to reimburse the customer. Therefore, the judge's discussion of Quint's Care took place on an erroneous footing, and it's perhaps for these reasons that Chitty refers to the aspect of the decision relating to Quint's Care as being, quote, surprising. That's at page 6616 at the foot of the page. In any event, the case says nothing about the potential application of the Quint's Care duty to an APP fraud case, as the case concerned an unauthorised transaction.
So this is a case where the ambit of the mandate is governed by a duty to exercise reasonable care, which runs consistently with any Quint's Care duty that could otherwise have arisen. Is that right?
Well, the mandate provided, perhaps show my law, the passages that include this. So if my lord looks at page 2815, the bank had sought to rely on various contractual terms as to why it wasn't in breach of mandate in paying out, even though the instruction wasn't properly authorised. And at 93, the judge said that the bank's reliance on the various provisions turns on the question of negligence, and therefore the mandate basis tends to merge with the duty of care basis. And then he says, I think the bank were negligent anyway, and therefore they can't invoke the contractual terms, which allowed them to have paid out, notwithstanding the instruction wasn't authorised.
So the substance is, as the judge says, the mandate basis runs consistently.
Correct.
With the duty of care basis, but you say that you don't dispute that, but you say you get there by saying there's an absolute mandate
yes.
not to pay against a fraudster's thing, instruction. That was qualified, so it was said, by the terms of the banking contract, which gave the bank some latitude in relation to that, but only insofar as they weren't negligent, which is what then makes the duty of mandate, in effect, exactly congruous with the duty of care.
Yeah. And there was no, in circumstances where he'd found against the bank on the mandate basis, there was simply no need to go on and talk about QuinceCare, because QuinceCare wasn't apposite in that situation.
Yep. Okay, thank you.
So my lords, for all those reasons, and those set out in our written case, and indeed in the written case of UK Finance, the bank respectfully submits that the appeal should be allowed. I've come in, I think, slightly under time. If I may,
No need to apologise.
If I may, I'll carry that across, or hold it in reserve for my reply. If I...
Well, it doesn't work that way. It doesn't quite work like that.
Well, can I ask you a question before you sit down, as we've got the time in hand? What is the limit, if any, on the situation of the bank? I mean, because this is an argument used against you, whether a hypothetical case where the bank has actual knowledge
Yes.
that it's a fraud.
Yes. Yes, so that was a point that certainly troubled, I think, Lord Justice Burst. There's a point that my learned friend has obviously adverted to in his written case. That is obviously not the fact pattern here. And I accept that if the bank had actual knowledge of the fraud, it's likely that it would be in breach of mandate by paying. And I say that because I would accept that the bank owes an implied duty to the customer to act honestly, and paying in circumstances where the bank knew of the fraud, such that the bank effectively became a party to the fraud by facilitating it, would likely be a breach of that implied term of honesty. But with respect, I'd say it's impossible to draw from that an argument that even where the bank does not have actual knowledge, it could be under a duty not to pay when it's received a valid instruction.
So that sounds as though that aspect of the duty is really congruous with dishonest assistance on the part of
Yes,
the bank.
obviously in an APP fraud context, it's difficult to envisage how a dishonest assistance claim would arise, because obviously the bank wouldn't be dishonestly assisting a fiduciary, which it would in an ordinary QuinceCare scenario, because obviously the fraudster is not a fiduciary. And obviously there's not a breach of trust. There's no dishonest assistance and a breach of trust. So depending on the fact pattern, one might not easily be able to fashion a dishonest assistance claim. But I would certainly, I think, accept that if the bank had actual knowledge of the fraud and became a party to it and facilitated it, then there would at least be a good arguable case that it was in breach of the implied duty of honesty.
So what if the bank has knowledge that that the payee may be party to an APP fraud? It doesn't know that it's a fraud, but they have information about the fraudulent scheme.
I'd say that's not a breach. I mean, if you're looking at the question as one of honesty, one is then required to identify.
That, but you say that simply gives rise to
because that kind of, if I may respectfully say, allies the dishonesty standard with the negligence standard. I mean, one is simply trying to identify: does the bank have actual knowledge of the dishonesty of the dishonest conduct, and that requires obviously, what was classically labelled as Baden categories 1 to 3, but not 4 and 5.
Can I just make sure I've got this clear in my mind? So you're approaching this on the basis that QuinceCare itself and the line of authorities on similar fact patterns is concerned with circumstances where the bank, trade agent of the customer, is put on notice of the possibility that the instruction being given to it by the customer's agent is not a duly authorised instruction. And And then in situations which simply concern the bank and the customer, we've got the case of Hilton illustrating that if the instruction is not clear, then the bank has a duty of care to clarify it before implementing it.
Yes.
And the Singapore case, if its correctness is accepted, suggesting, I think, that if the mental capacity of the customer
Yes.
is, if the bank is again put on inquiry
Yes.
as to the customer's mental capacity, and therefore whether the instruction is a valid instruction.
It's the same reference point. Is it valid?
Duty of care. But other than in all these situations concerned with whether the instruction is a properly authorised instruction, whether coming directly or indirectly, leaving those to one side, you say the duty of the bank qua agent is one of honesty.
Yes. Well, I would accept that it is an implied term of the mandate that the bank will act honestly to its customer, and equally is an implied term of the mandate that the customer will act honestly to the bank. So it's a two-way implied obligation, and that if the bank actually knows there's a fraud and facilitates it, then obviously it's not this case. But in that situation, it's difficult to see that the bank wouldn't be in breach of that implied term.
Yes. Yes. So effectively, and putting it shortly, the duty of care arises where there are reasonable grounds for a reasonable banker to question the validity of the instruction, but where he has an unquestionable instruction, or is one where he has no reason to suspect the instruction, his duty is to carry it out, unless that would conflict with his overriding duty of honesty towards the customer.
Yes, and I suppose also subject to poker.
Yes,
money
of
laundering.
course, yes. Yes,
And that's right. And whether one characterises my lord's first category as Quince Care or one characterises it as East India, you end up broadly in the same place. As I said at the beginning, the agency analysis doesn't provide any explanation for the extended Quince Care duty as found by the Court of Appeal. It's simply impossible to fit that in within any sort of East Asia type analysis.
Yeah. I'm conscious I'm putting words effectively into your mouth while you're on your feet. You may think the better of some of exactly what's been said on further reflection. It's just to get to clarify my own thoughts. Thank you very much, Mr. Goodall. Yes, Mr. Lane.
As your Lordships know, UK Finance is the trade body representing the banking and finance industry, and it has more than 300 members across the full scope of the industry, including not only the largest banks, but also small online or start-up payment service providers. And in our written case, we set out the industry concerns about the significant extension of the Quince Care duty. And Mr. Goodall has addressed your Lordships on our first concern, which is the fact that the duty extends all prior authority and does so, we submit, in an unprincipled way. In my submissions, I'd like to address you on three further concerns the industry has. The first concern is that the judgment of the Court of Appeal completely failed to have regard to the current regulatory regime, and indeed is inconsistent with it. The second and related concern is that the judgment ignores the extensive work undertaken since 2016 and which is ongoing specifically to address APP fraud with a regulatory response. And the third concern of the industry relates to the practical impact of the judgment on payment service providers and on the banker-customer relationship more generally. And we've canvassed some of that already. I won't repeat the submissions made. So starting first with the regulatory regime, the key instrument is the Payment Services Regulations 2017. That's at page 3095 of the authorities bundle. And remarkably, the Court of Appeal's judgment did not even mention these regulations. And that's surprising because these regulations regulate the execution of payment instructions by banks and other payment service providers. And indeed, they gave effect to the Second Payment Services Directive, which was specifically created to harmonise payment services across the EU. And for your reference, that's at page 6329 of the authorities bundle. As we say in our written case at paragraphs 24 and 25, it is vital that the United Kingdom continues to give effect to the rules and policies contained within that regime to be able to continue to participate in the single euro payments area payment systems. And indeed, there is no suggestion that any other country in the EU, or indeed anywhere else in the world, imposes a duty on payment service providers to refuse or delay authorised payments. And the reference to that is in the consultation paper provided from the regulator, and it's in the bundle at Appendix 2, page 724, paragraph 5.22.
Please reference again.
It is Appendix 2, page 724, and the relevant paragraph of the paper, which was published in November 2017, is 5.22. And the time available, my lords, may I just highlight the key provisions of the regulations? I won't suggest I take you through them, but we can look at any that your lordships wish to. They're very helpfully set out in Barclays' written case at paragraph 91. And there are 4 key points I'd like to make, if I may.
And can I just ask, the UK's continued participation in the single European payments area is something that is intended, is it, notwithstanding Brexit?
It is. It was deliberately retained. These regulations were retained post-Brexit in order, and we address this at paragraph 24 and 25 of our written case.
Thank you.
And in fact, there was a specific application made by UK Finance on behalf of UK-based payment services providers to the European Payment Council for the continued participation in SEPA schemes. But that is subject to the continued satisfaction of the participation criteria, including compliance with these regulations. So in relation to the regulations, there are 4 key points that are material. First of all, there is a clear emphasis on prompt and certain payments. And the emphasis can be seen in the recitals to the Second Payment Services Directive, which are set out in paragraph 21 of our written case. And the policy is given effect to, essentially, by imposing an obligation on the payment service providers to make most payments within clear timeframes and usually within 1 business day in most cases. And the relevant regulations are regulations 82 and 85. The second point that is to be derived from these regulations is that a clear distinction is drawn between authorised payments and unauthorised payments. And we see that in Regulation 67, which is headed Consent, and withdrawal of consent. And so far as authorised payments are concerned, Regulation 67 simply says payments are authorised if the payer has given its consent.
Sorry, which page is that?
This is page 3148.
Okay.
So, my Lord, you see a payment transaction is to be regarded as having been authorised by the payer for the purposes of this part only if the payer has given its consent. Now here, there is of course no debate that the transactions are authorised transactions. And what's interesting about the regulations is the question of how a principal or company gives consent is left to ordinary principles of agency. The third point on the regulations is that in the case of authorised payments, the bank's liability for making the payment is strict. So far as the customer is concerned, there is generally no right to reimbursement, with one important exception. And the exception one can see in Regulation 79, which is at page 3156. And this deals with direct debits, which are authorised, but essentially which exceed the amount that the payer could reasonably have expected, taking into account the payer's previous spending patterns, the conditions of the contract, and the circumstances of the case. So in other words, if a customer gives authorisation for a direct debit, but then whether or not through fraud, the payee requests a larger payment than could reasonably have been expected, the payer is entitled to a refund. And the relevance to the present appeal is that this shows that liability in respect of authorised payments was specifically considered and direct debits were addressed, but there is no equivalent provision for authorised push payments. And we submit, as Barclays does as well, that it would not be consistent with the scheme now to create such a liability under common law.
Presumably APP fraud has grown since this time.
It has grown, but it was on the horizon then. And of course, as I'll come on to address, that is why the regulator is now looking at a regulatory response. But what's clear is that the existing regime does not encompass APP payments by way of an exception. And in particular, my Lord, if we look at Regulation 90, which is at page 3161, this is the provision that actually the regulator regards as the roadblock for dealing with APP payments under this regulation. And it's this provision that needs to be addressed or removed or amended to permit the regulator to impose obligations in relation to payments made as a result of APP fraud. And that's what the regulator has said. So what this provision now shows is that as things stand, there is not an exception for APP fraud. And if you look at this, my lords, what you will see is that the regulation provides in subparagraph 1 that where a payment order is executed in accordance with the unique identifier, which is essentially the bank account number, and you see that from Regulation 2.1, the payment order is deemed to have been correctly executed by each payment service provider. And if the unique identifier is incorrect, then the PSP is not liable under regulations 91 or 92 for non-execution or defective execution, but it needs to make efforts to recover the payment. And then if one moves down to subparagraph 5...
Oh, I see, just referring to the account number of the payee,
Yes.
presumably.
That's right.
Yeah, I see.
Yes, so if you get an instruction to pay into a particular account number, there's a deeming provision which
That's right.
you say would have to be set aside if you were to cater by regulation for EPP fraud.
Exactly. Yeah. And that's the way the regulator has also looked at it and give you the references to that. So you see that in footnote 24 to our written case, that one sees it, that point made in the explanatory notes to the Financial Services and Markets Bill of December 2022. It's also in the Consumers Association report of August 2020, and it was also in a statement made to Parliament. And what the regulator has said is this provision, combined with the fact that the directive is a full harmonisation measure, means there's no possibility of making payment service providers liable to reimburse payments caused by APP fraud, assuming Regulation 90 kicks in. And subparagraph 5 makes it clear that even if the customer provides additional information, so, for example, the account's name, it doesn't matter because the payment service provider is liable only for the execution of payment transactions in accordance with the unique identifier. And that's all been reinforced by two decisions. One we refer to in paragraph 21E of our written case, and that's the CJEU decision of the Techno Service. And the second is the tidal energy case. And both of those make it plain that there has been a policy decision that the need for prompt and certain payments outweighs the risk that customers might suffer loss through their provision, whether through fraud or otherwise, of an incorrect unique identifier. Now, none of this was addressed by the Court of Appeal in their judgment, and we say that that was a very serious omission, akin to the criticisms made in the Murphy case, because the regulations obviously have a clear and binding effect, and they also seek to advance consumer protection in a particular way, balancing the need for speedy, certain payments with certain protections, for example, as things stand, direct debits, but recognising, as I'm going to come on to, that there may need to be an exception for APP fraud. So
the effect of that submission and Regulation 90 is that you're not saying this is an area where Parliament is getting engaged. You're saying this is a statutory statement as to the validity of the transaction, and for the court to develop the common law would be going against the grain.
Exactly right, my Lord, and that's why we cited the words of Lord Hoffman in footnote 8 of our case, in the Johnson and Eunice case, yes, that judges mustn't develop the common law in discord with statutory policy. And we say that is what has happened in the Court of Appeal.
But are you saying, as I understand it, that if the Court of Appeal decision stands, then a bank could be in a situation where it has conflicting regulatory and common law obligations?
That's right. And that was going to be my third point, which I'll come on to, which is the practical implications are very difficult because the bank will be in conflict. The two other regimes that I'll briefly mention are the Banking Conduct of Business Sourcebook, which those provisions are addressed in our written case at paragraph 26, and they apply to deposit-taking firms if the 2017 regulations don't apply. For example, these rules apply to cheques and to credit unions, so two areas where the regs don't apply, and they are entirely consistent with the regulations, and they provide for liability only in the case of unauthorised transactions, and they also provide that where a payment is executed in accordance with the payment routing information, it shall be treated as correctly executed. And that's paragraph 5.1, 15R. And for the reasons Mr. Goodall has already explained, the Proceeds of Crime Act is also consistent. Can I then turn to the current work that's being undertaken by the regulator and the legislature to address the specific issue of APP fraud? And again, this is not addressed in the judgment of the Court of Appeal, even though it was on foot at the time of that judgment. And I won't develop this at length given the time. We address in our written case at paragraphs 33 to 36, first of all, the significant work that has been undertaken to develop a voluntary code for reimbursement of the victims of APP fraud. And that code was adopted in 2019. And UK Finance has been at the forefront of that work. We're now in the position where the legislature and regulator are on the cusp of approving the mandatory code and imposing it. And the precise conditions for reimbursement at the moment are under discussion. But what is clear is that Parliament and the regulator are steeped in the policy considerations that underpin the appropriate extent of consumer protection in the context of APP fraud.
I'm not sure it's a fair criticism of the Court of Appeal to say they should have referred to this, unless you're accepting, which I don't imagine you are, that it's part of their job to be regulating fraud for the benefit of consumers.
The criticism is that we refer to the guidance of Lord Bingham in our written case and say that that is the criticism that I'm making, which is when Parliament is actually engaged in considering an issue, as Lord Bingham said, the court generally should not seek to preempt the outcome of that deliberation and change the common law. And that's the criticism made, not that Lord Justice Burst should have engaged with the content of it, but it should have been another pointer to not stepping in.
Well, the Court of Appeal made aware of the statutory background and the developments?
I'm looking at Mr. Goodall, who's there, and I'm told yes. And there was certainly a lot of information about it. Mr. Goodall is saying that plainly the Court of Appeal were not made aware of the bill because the bill has only passed its second reading in the House of Lords on the 10th of January 2023. But there was a lot of writing because this has been a long time in the making, and it was clear that this was under deliberation. Just so your Lordships know, the regulator anticipates the bill will come into force and that the mandatory reimbursement model is required to be in place within 6 months of that date. And really, I mention that, first of all, for the points that I've just addressed my Lord Legate on, but also to reassure the Court that a solution for APP fraud is under consideration, and the regulator is well aware of it and is trying to address it and intends to address it. And that, again, is a pointer to not using a wide-ranging common law duty to address something that is already going to be targeted and specifically addressed.
It may be said against you that, of course, given that this involved international payments, it won't be addressing this particular type of fraud. If the fraudster persuades some poor person to send money to the Middle East, as happened here.
That's a fair criticism to the extent that at the moment, and it seems likely, that the regulator will only be able to look at non-domestic transfers. But That is currently certainly the ambit of the discussion. Obviously, this case wouldn't necessarily be covered anyway, because the legislation won't come in retrospectively.
Clearly.
But the reality is that a wide-ranging common law duty to address a limited number of transactions we submit can't be the way forward in light of both the existing regulatory regime and the likely future regulatory regime.
I fully see the point, but I'm just saying that what is proposed at the moment won't cover the whole field.
No, it won't.
It might be said that it doesn't really matter what's proposed. The point is that the regulator and Parliament are seized of the issue, and even the existing legislation shows that Parliament has occupied the field, so to speak. If they decide to do nothing about it, that's up to them. They're in a better position than the court is to determine the appropriate policy.
Precisely right, my Lord. My Lord, then, may I then move to the practical concerns, which is something my Lord Reid raised this morning, and that is the third concern of the industry, and that can be broken down into three elements. First of all, and we've covered this in detail today already, the duty undermines the well-established and clear obligations of a bank to honour the customer's mandate and to provide prompt payment in accordance with the customer's instructions. And it's well established as a matter of law, as Mr. Goodall has explained, that the mandate is sacrosanct, and the new duty also undermines the bank's status as an on-demand creditor. It also, as my Lord Legate has pointed out, it undermines and places the bank in conflict with its obligations in the current regulatory regime. The second element is that the new duty is inherently uncertain in its application. And as Mr. Goodall has already identified, the respondent's case is that the banks are under a duty to interpret, ascertain, and act upon a customer's really intended instructions. I think we looked at that this morning. That's in the respondent's written case at paragraphs 44 to 45. And that expression, as Mr. Goodall explained, comes from the words of the judge in the Selinger case, which of course involved the classic Quince Care agency situation. In a case like that, it is straightforward, potentially, to talk about a customer's real intention being that of the principal and not of the fraudulent agent. But the expression is not apposite, as we've already discussed, to cover a situation where the customer has themselves given the payment instruction to the bank for the reasons identified by my Lord Legate. Because in that scenario, there can be no doubt that the customer really intends to instruct the bank to make the payment. But just standing back from the perspective of what's actually being said underpinning that expression, what the respondent is actually saying is that the payment service provider must consider the prior dealings between the customer and the third party which have resulted in the customer's genuine instruction to make a payment, which takes you into really saying the customer's motivation or rationale for giving the instruction and whether such motivation or rationale has been induced improperly or is otherwise imprudent. And it goes that wide, otherwise imprudent. And you can immediately see the difficulties of the industry with that approach, first of all as a matter of law and having regard to its regulatory obligations, and secondly in practice. Because as a matter of law, it's clearly no part of a bank's duties to advise against or intercede in or prevent the customer from making a payment if the customer chooses to do so. And we've looked at already the Redmond and Allied Irish case. There's also the decision of my Lord Hamblin at first instance in Shah and HSBC, where my Lord held that a bank has neither the responsibility nor the expertise to investigate criminal activity, as at paragraph 52 of the case. And likewise, we say it's no part of the bank's role to be the guardian of the customer's best interest or be responsible for divining the customer's real intentions. And I don't know how that would even be possible. And just to outline some of the obvious practical difficulties, working out whether the bank is on inquiry with that type of obligation would be almost impossible, particularly given the huge number of payments in issue and the fact that we are by definition addressing authorised payments using mainly automated systems. And the duty pleaded in this case is that a bank must have systems and analytics in place to monitor all payments and assess the risk of APP fraud. That's the duty pleaded. Of course, this duty goes much wider because it's not limited just to APP fraud, but potentially arises in every case where the bank considers the payment may be imprudent or mistaken. Now, having regard to the width of the inquiry, one then can say that many of the features which seem to indicate fraud are present in many bona fide transactions. And so the consequence is that a vast number of payments will be flagged on any system any payment service provider can create to try and meet what seems to be the duty imposed. And the bank will be on inquiry in respect of millions of payments. The scale of that is potentially enormous, and it's crippling, particularly if it's even possible it will be crippling for smaller payment service providers. You then have the next stage, which is once the bank is on inquiry, the new duty, it seems on the respondent's case, requires the bank or payment service provider repeatedly to challenge the customer. So on the facts of this case, not even a second confirmation would have been enough. On the facts of this case, it would have been necessary for the bank potentially repeatedly to refuse to action the payment and to disbelieve the explanation given by its customer. So the safest course for the bank or payment service provider would be then to block payments, or at least delay them for some period of time. Now that takes the bank and the customer into very unsatisfactory territory. So far as the bank is concerned, it could render the bank liable for the customer's losses, and the Westpac case, which is in the bundle at page 6217, is a good example of that. Alternatively, the customer will suffer loss but won't have any recourse because the bank will have contracted out of liability for delayed payments. And that's assuming that the bank takes the step of blocking the payment. It's actually impossible to know, and it certainly isn't possible through, quotes, ordinary banking practice, as my Lord Legate said, to know quite what the bank or payment service provider is supposed to do in the infinite variety of situations and payments that this duty could apply to. And if the target, which it seems to have been, the target of Lord Justice Burse's duties imposition was APP fraud, one comes back to the fact that that is actually being specifically looked at as a separate category now by the regulator and the legislature. This duty goes far wider and doesn't just target that area.
Well, just out of interest, is it proposed as part of the regulatory intervention or legislative one that the banks will have to do more to try and detect and prevent this, or are they just taking the hit when it happens and paying out?
It's currently under discussion, and there is a combination of proposals. The first is a combination of warnings or system flags.
Because, I mean, to the extent the first is true, it somewhat goes against the argument that it's unworkable or impossible.
Well, it may not be unworkable for APP fraud, on a limited basis, but that's why I'm saying it's unworkable, because this duty isn't limited to APP fraud. It could go simply to imprudent transactions or mistaken transactions.
Yes, I mean, the respondent's case expressly goes as far as to include mistake.
Exactly. So it's not limited to that. The second point is that under the regulatory proposals, the hit is going to be taken, it said, between the receiving bank and the paying bank, 50% each. But there are queries at the moment under discussion as to whether, if it goes too far, it will be perceived as a victimless crime and only enhance the amount of APP fraud. And so some customer responsibility is being looked at to be imposed so that doesn't happen. So it's quite a policy-driven area, but the point is that to the extent that system controls can be put in place, that's not the only remedy. It's actually, as my Lord says, taking the hit as well. The final element of the concern that the industry has is the justified concern, given everything I've said, that the new duty will have significant unintended adverse consequences. And we address this in our written case at paragraphs 49 to 58. And briefly, it's self-evident that a substantial new duty will result in further costs for payment service providers, either in the form of new liabilities to customers or in substantial compliance costs, monitoring the transactions, checking the payments, etc., ringing the customers to check the payments. And inevitably, these costs, first of all, are going to be of more concern to smaller or challenger payment service providers, but fundamentally will rest at the customer's door, ultimately. So these increased costs, particularly from the uncertainty of monitoring, will ultimately be passed to the general customer base. And it's also inevitable that some bona fide payments will be delayed or rejected, and that will cause irrecoverable losses. And what we submit, my lords, is that the new duty is likely to have a chilling effect more generally on the speed and certainty of payments, and completely undermine the regulations, and completely undermine the United Kingdom's position in this regard, being the only country that would have such a situation. We say none of these adverse consequences are justified, but to the extent that there are cost ramifications and consequences that are justified in respect of APP fraud for consumer protection is a policy matter. And the regulator and legislature can seek to mitigate adverse consequences by a carefully calibrated regime which can't be achieved by the common law. My Lord, those were my submissions, unless you have any questions.
Phil, thank you very much, Ms. Delaney.
I'm going to cover the same three areas that my learned friend Ms. Talani covered, but to take them in a slightly different order, and to begin with the practical concerns. My Lords, footnote 28 to UK's Finance's written case on page 175 gives a figure for the number or the percentage of transactions made by 3 of the most common payments networks that are affected by APP fraud. As a percentage, with 4 zeros and then 3 5, it's a little difficult to digest. It equates to 1 in every 2,850,000 payments. APP fraud is a low probability, but from the consumer's perspective, high impact event. And UK Finance, in its recent response to the Payment Services Regulators consultation, lists as its #1 action to prevent fraud, and your lordships will find this on page 1980. Top action to prevent fraud, allowing firms to slow a small number of high-value payments where fraud is suspected. And that observation is repeated by UK Finance in its response to the consultation at page 1989, where it observes that the impact on consumers where APP fraud does arise can be life-changing, and so a proportionate solution which enables PSPs to hold payments where risk is identified would appear to be the right result. My Lords, that approach is what the Court of Appeal's decision requires banks to do. I've listened carefully to my learned friend Mr. Goodall's submissions, and particularly his answers to questions posed by your lordships. Would banks face the prospect of liability if they transfer to a third country bank account a large sum of money despite the customer volunteering that the customer is making the payment because they've been told by the police to move their money to a safe account? I think before lunch, Mr. Goodall equivocated in answer to a question on that point. I think I understand his considered position to be that he would accept that they were liable. Secondly, would banks face a possibility of liability if they processed a fraudulent payment despite having received a fraud report that a company was carrying out scams targeting the bank's customers? Now, those facts arose in relation to a payee's bank in the case of Technimont, which your lordships have at 5319, but the claim against the paying bank the receiving bank rather, ran aground as being no contractual relationship. My Lord Sales asked the question about whether one might formulate or reformulate the Queen's Care duty in a way that is congruous with dishonest assistance. Of course, the difficulty with dishonest assistance as an effective remedy is the need, even in a large organisation, to identify an individual employee who has been dishonest. And some of your lordships may remember that in the Stanford International case, at first instance and before the Court of Appeal, there was an attempt to aggregate the knowledge of HSBC to arrive at a sort of corporate understanding that could be classified as dishonesty. And that was rightly rejected as heresy. So what then about the third scenario, in which one has a little old lady who's never spent more than £10,000 on anything, who now suddenly wishes to make an in-branch payment of £750,000 to an account in Panama? I understand Mr. Goodall's position to be that unless the bank knows that that is a fraud, it faces no liability. My Lords, the development of the law in this area needs to be set against ordinary banking practice. An ordinary banking practice in this area already involves banks routinely giving themselves a contractual right to stop payments. In relation to Barclays, at the time of the facts of this case, your lordships will see that at the bottom of page 392 and at the top of page 393. And your lordships will see on 393 a whole section entitled "When We Do Not Have to Follow Your Instructions," one of which, the fourth bullet point, is where we reasonably think a payment into or out of an account is connected to fraud or any other criminal activity, including where the funds are being obtained through deception. And Barclays' provisions in this regard, in those terms and conditions back in 2018, are reflective of the position with regard to the industry today. In footnote 13 to Which's written case, we list references to a series of examples from banks, both large and well established, and also ones that might be described as challenger banks or new entrants into the space. And my lords, all of that is important because a somewhat atomistic approach was taken by the bank in relation to the payment instruction. The reality is, of course, that the instruction takes place within the context of a banker-customer relationship. Now, that's not a relational contract, so-called, but nonetheless it is a collection of rights and responsibilities which has to be seen as a whole. And in contemporary banking practice, those rights and responsibilities include banks routinely delaying payments when they suspect there are markers of fraud or financial crime or money laundering, and also banks warning their customers when they think that their customers may be at risk of fraud or financial crime. So, my lords, we say that banks ought to, and already do as a matter of ordinary banking practice, monitor payments concerning a range of frauds and other financial crimes, and are not just narrowly limited in terms of their inquiries in relation to payments to questions of whether a customer's agent might be misusing their authority. Well, we list at paragraph 17 of our written case, at page 188, various provisions and industry standards that are described in more detail by Mr. Green in paragraphs 22 to 24 of his statement at page 371 to 372. These include, my lords, the banking protocol, details of which are conveniently summarised in a Financial Ombudsman Service decision at page 1175. They include the British Standard Institute's Code of Practice at pages 653 to 671. They include a best standards platform, details of which are at 2006. And my lords, those initiatives supplement and complement regulatory duties that fall on banks. My lords, those regulatory duties include the duties of CISC 3.2 on page 3269, and my lords, on 3269, you'll see at 326R, a firm must take reasonable care to establish and maintain effective systems and control for compliance with applicable requirements and standards under the regulatory system and for countering the risk that the firm might be used to further financial crime. And your lords will then see a separate 326A dealing with money laundering risk. So it's important to note there that financial crime and money laundering risk are being dealt with separately. And under the payment services regulations, 3109, you have Regulation 6.6, which requires payment services providers to have effective procedures to identify, manage, monitor and report any risks. And at Regulation 2317 on 3122, requirements in relation to relevant funds, which are funds that PSPs are required to safeguard. A requirement to have procedures to prevent a PSP from being used to facilitate fraud, money laundering, or other financial crime.
Which regulation is 3122?
2317, my lord.
2317, thank you.
But, my lords, perhaps most important of all in this space is Commission Delegated Regulation 2018 on page 6308. There has been some discussion today about how all of this would work in a world where algorithms are doing a lot of the checking. And my learned friend Ms. Talani made some somewhat interorum submissions about the risk of excessive false positives. Your Lordships will look at page 6312. Bottom of the page, your Lordships will see a heading, General Authentication Requirements. And what your Lordships will see there is a requirement for PSPs to have transaction monitoring mechanisms in place that enable them to detect unauthorised or fraudulent payment transactions. And there's then a description over the page on how they are to do that, with an analysis of payment transactions, taking into account elements which are typical of the payment service user, and picking up under Article 2.2 items including C, known fraud scenarios in the provision of payment services. And, my lords, if one continues to 6318, your Lordships will find there, at Article 18, a lengthy description of how payment service providers are to engage in transaction risk analysis, including at 2C, performing real-time risk analysis in relation to abnormal spending or behavioural patterns of the payer, and at 4, known fraud scenarios.
Well, I suppose banks already have to monitor against the risk of somebody getting access to your bank account and starting to make payments out of it.
My lord, I accept that they're there to do that. They're not there specifically to deal with APP fraud.
No, I was making a point, as it were, in your favour, that
yes.
That is something they're already used to doing. I mean, they're already monitoring. You get, a call from fraud prevention, don't you, when a suspicious transaction, or what might be, gets made on your card or something?
My lord, yes. And my lord, they're doing that, and there's a regulatory framework for doing that, and any of the new entrants into the PSP space have to meet these requirements as a condition of being able to set up as a PSP. There's something slightly odd in my learned friend Mr. Talani's submission, that because some new entrants might have difficulty in meeting a standard of care, that would be a reason for there not being a duty of care. So, my lords, I say that existing banking practice, and of course you have limited evidence about that. More evidence of banking practice was available both to Mrs. Justice Rose in Singularis and to Mrs. Justice Cockrell in Nigeria. They both heard evidence from banking experts. Neither of those distinguished judges expressed any difficulty in fixing what banking practice was, with the benefit of expert evidence tested under cross-examination. My lords, let me turn then to the second of the points I wish to address you on, which relates to the current regulatory regime and the suggestion that the current regulatory regime is inconsistent with the existence of the Queen's Care duty as formulated by the Court of Appeal. My lords, the regulations in the UK implement the Payment Services Directive. There are a number of recitals to the directive. My lords, I would draw your attention to recital 70 on page 6340. Lords, there are 2 points to make in relation to recital 70. The first is it makes it very clear that the focus of this directive is on unauthorised or incorrectly executed payment transactions. And the second, my lords, is the final sentence in recital 70, that this directive should not affect other claims between payment service users and payment service providers. And my lord, that indication is reflected in Article 107 of the directive. Article 107 is headed Full Harmonisation. It's on page 6404. But it makes it clear that it is only insofar as this directive contains harmonised provisions that member states shall not maintain or introduce provisions other than those laid down in this directive. And also, to make sense of the payment services regulations, one then has to put them in the context of the directive. And in relation to the directive, Title 4, which begins at 6383, is the relevant part of the directive. Title 4 contains a number of different sections. On 6385, we see a section headed Authorisation of Payment Transactions. That covers Articles 64 to 77. And then on 6392, we find the next chapter, Chapter 3, is headed Execution of Payment Transactions, and that covers Articles 78 to 87. So my lords, the structure of the directive is, insofar as is relevant, it's concerned with questions related to authorisation in one chapter, and then questions relating to correct execution in another. That distinction is reflected in the regulations, so that it is regulations 67 to 80 that are dealing with authorisation, and regulations 81 onwards that are dealing with execution. Once your lordships have that in mind, then it becomes possible to untangle the submissions advanced by Miss Talani. So the case of Technoservice, to which she referred, was a case about execution. It's not about fraud at all. And it's a case about a point directly concerned with Chapter 3 of the directive, dealing with execution of payment transactions. What must a bank do in terms of mechanics in order to execute a payment transaction correctly? And that is also, in our submission, why Regulation 90 is not a bar to the court and the common law in this area. Regulation 90 at page 3161.
But the regulator thinks otherwise.
The regulator does think otherwise. That is not the view of the Consumer Association. We think that what has happened is that the regulator has failed to draw that very clear distinction between the provisions that relate to authorisation and the provisions that relate to execution. And let me explain why that is. As my learned friend Ms. Talani pointed out, Regulation 90, Sub-Regulation 2, shows that what Regulation 90 is concerned with is the circumstances in which a paying institution may face regulatory liability under Regulation 91 or 92 for non-execution or defective execution for payment transaction. So Regulation 90 Sub-Regulation 1 tells you you're not going to face liability if you make the payment in accordance with the correct unique identifier. Regulation 90 Sub-Regulation 2 says, well, if the payment service user gets the thing wrong, then there are various things you should do to help, but there isn't a liability there. And Regulation 90 Sub-Regulation 5 makes clear that where there is additional information provided, well, you don't have to take that additional information into account. For the purposes of the regulatory liability relating to correct execution, the unique identifier is everything. In that respect, the regulations line up with the decision in Tidal Energy, which was a 2014 decision predating the entry into force of the 2017 regulations. So the problem that Regulation 90 is addressing is what information is a PSP required to check in order to determine that it's making the payment to the party its customer has directed it to pay. It's not broader and doesn't preclude any liability of the type that arises in APP fraud cases. The other regulation then to look at in that regard is Regulation 82. That's on page 3157 at the bottom of the page. Regulation 82 expressly contemplates the possibility of a payment service provider refusing to execute a payment order. Now, the circumstances in which that is possible are limited. The limitations come in Regulation 82.5. 82.5 begins by saying where all the conditions set out in the framework contract with the account servicing payment provider have been satisfied. And the account servicing payment provider is any sort of PSP that's providing the equivalent of a bank account. That's provided in the definition section above. Then the account paying service provider may not refuse to execute the order unless the execution is otherwise unlawful. Well, both the beginning and the end of that regulation contemplate the possibility of an payment instruction being refused. As your lordships have seen, when I took you briefly to Barclays terms and conditions, if the bank has given itself the contractual right to pause a payment where it is concerned about fraud, well then the conditions set out in the framework contract might be said not to have been satisfied, so the payment could be refused on that ground. In the alternative, where there is a duty to the customer to stop the payment or to make inquiry, well then executing the payment without doing so would be unlawful. And my lords, there's one other important consequence. Your lordships will see under Regulation 82.6 that for the purposes of various other regulations, including 91 and 92 relating to execution, then the payment order is deemed not to have been received. So in our submission, there is no difficulty in relation to a regulatory liability arising if a bank were to exercise its right to refuse under Regulation 82. There's no lose-lose. Moreover, there is no implication of the pausing of a small number of payments because of suspected APP fraud on the UK's continued membership of the single euro payment area.
But how would one confine a common law rule to APP fraud rather than any other fraud, given that the common law develops by general principles?
Well, my lords, the rule already applies to fraud by a customer's agent.
So would your submission remain good if it was every type of fraud? And also, would it remain good if, as the respondent suggests, it would cover mistake?
Well, my lords, I think it's right to say that my clients have no position on mistake. Our concern is the rise of APP fraud, and and my lord, it should be said, Mr. Goodall suggested this morning that it might well be the case that the customer knows more about the APP fraud than the bank does. Of course, precisely because banks have to monitor transactions, it will often and usually be the case that the bank will be in a better position to spot that this is an APP fraud. Now, my lords, I think in the limited remaining time, I want just to deal with the position with regard to pending changes. And my lords, two things to say about that. My learned friend, Ms. Talani, was not quite accurate with regard to her timings. The Court of Appeal handed down its judgment in Philipp and Barclays Bank on the 14th of March last year. The Financial Services and Markets Bill was introduced into the House of Commons in July 2022, 4 months later. The bill does not seek to overturn the Court of Appeal's decision, either expressly or by implication. Nor has Parliament indicated an intention to restrict the effect of the Court of Appeal's decision to payments made using certain payment instruments or payment systems. This is not a situation in which Parliament has expressed an intention to eliminate the powers of the courts to decide whether a duty of care arises in a particular situation, and if so, what its extent is. There has been a flurry of activity since July from various quarters. After the bundle was finalised in this case, the Treasury issued a Payment Services Regulations review. Treasury has not indicated in that review that the decision in Philipp and Barclays Bank impacts on its proposals. And that is in marked contrast to its reaction to another Court of Appeal decision given in March of last year in a case called Re-Ipogu Limited, or Re-Ipogu LLP, which relates to safeguarded funds. Moreover, as your lordships have already observed, the proposed regime does not cover the entire field. The proposed legislative and regulatory changes do not cover payments not made through the faster payment system, do not cover international payments. And so it will be the higher value and harder to recover payments which will still not be protected. That would leave a small number of payments which are of high impact to the victim, where the common law rules would apply. The limited number of cases and their significance from a customer perspective make the imposition of the carefully calibrated Queen's Care duty fair, just and reasonable. It should, of course, be remembered that all that the Court of Appeal did on an appeal from summary judgment was to say that it ought to be left to trial once expert evidence was available and had been tested, once the facts had been fully explored, to determine how the duty might apply. On behalf of the Consumer Association, I would urge your lordships not to shut the door.
Thank you, Mr. McElroy. Unless Mr. Sims is very keen to poison our minds before we adjourn, we're happy to adjourn now and let you begin tomorrow morning.
I'm more than happy to do whatever your lordships want. Your lordships received a brief note from us as well, I think, in relation to the direction, so
yes,
hopefully that's been of assistance to your lordships. And if there is any particular aspect of that which we need to explore further tomorrow, we can do so. We haven't troubled your lordships with all the authorities we referred to in it, but if on reflection your lordships think there are any particular ones that you want us to consider in more detail, we'll do that tomorrow.
Thank you. Well, before we adjourn, I'd like to say how grateful we are to both intervening organisations and our council for their assistance. We do value it and appreciate it. We'll adjourn now until 10:30 tomorrow.